welcome to I believe, all of our English-speaking followers. My name is Stephanie Mata, Associate Attorney here at the law offices of Beltran Brito Casimir. And by video accompanying me is the founder, Gil Brito. Gil, how are we doing today?
I'm doing very well, Stephanie. I hope everybody's doing well today. And we're coming back with our Q&A. We're doing it in English. If you want to request your question in Spanish, that's fine. We will do a quick translation, or better yet, Stephanie will do a quick translation and then tee up the question to me, or back and forth. I know we always like to start, Stephanie, a little bit of news. What's happening? Hey, election year, a lot of stuff happening. Immigration. Really interesting. They haven't talked too much about immigration in the elections. I haven't seen it. Yeah. I really haven't seen it. And I find that to be very interesting. I think I was reading an article recently about it saying, where's the immigration news?
It's not as much of a hot topic.
It's not. Well, it is a hot topic. Unfortunately, it's not being used by our politicians as an arguing point, and a pick a side type of situation. But there's a lot of immigration happening. Stephanie, lead us there. What's going on with the news?
So I think the most prominent thing that people are discussing now is the fee, right? So essentially the fees for USCIS were scheduled to increase on October 2nd. USCIS is a federal agency that really runs off fees. So the more fees they get, the better they are able to operate. That has actually been suspended currently due to some litigation in the courts. Right now, you can continue to submit your petitions with the old fees, and we should know later. Gil, we expect sometime in the near future, the fees will in fact increase. So get your case in early if your fee is going to be lower.
There's an opportunity, right? There's an opportunity right now, especially a couple of fees that I'm particularly concerned with is citizenship applications. Yes. Citizenship applications should be filed immediately. The fee increase, I mean, obviously, if you're eligible to file now, you should go ahead and file as quickly as you can. The fee increase is literally double. Okay. And it's ridiculous how much, especially for U.S. citizenship, which in my opinion is probably one of the easier applications versus some of these massive green card applications that it's going to take an immigration officer a very long time to analyze, review, and come to a conclusion. So take that into consideration. That could go up at any moment. Really important, Stephanie, let's put this in here. Talk to us about premium processing.
So premium falls into this category. Premium processing fees are slated to increase as well. Instead of being one flat fee, it will change depending on the petition you're filing. I think the highest fee, Gil, that we're seeing is something like $2,500. Eventually, that hasn't happened yet, but it is soon on the horizon. And the other prominent change with premium processing is that before it was 15 days, and it was essentially 15 calendar days. So as soon as you submitted the petition, weekends and holidays were included. Now the decision will arrive within 15 business days, and the days may also change. There is some flow of this, some information floating around that the amount of time will change depending on the petition. For now, it's 15 business days, and we will let you guys know should that change, right?
Yeah, I think this is like the first positive news I've heard from immigration in a while. The fact that there's going to be they're going to charge you some more money, but EB1C, multinational executives, never had premium processing. EB2 NIWs had premium processing a long time ago, and then it was suspended. Okay, so those are great categories of opportunity for premium processing. One more nugget that they've never done before is employment authorization documents, Stephanie, with premium processing. That is a boom for them, I think, financially. That is a great financial move on USCIS's part, because they're going to charge $1,500. And the people that want a quick employment authorization are more than willing, I think, to pay that $1,500 to have a very quick decision. I think the decision is going to be in the neighborhood of 30 days, 45 days versus 5 or 6 months. Okay. So I think that that's an unbelievable thing. And I would imagine many people are going to want to use that. Really quick, diversity lottery. It's open. Apply for it. I suggest you apply for it. It is free. Do not pay anybody fees to do this. I understand if you want to retain an attorney and it's a nominal fee and they're not charging you very much to do it, that's fine. Go ahead and do that. If you're paying all these services out there to do something that's free and they're not even attorneys, please don't do that. You could totally do it on your own. If you're eligible to do it, you should do it. Stephanie, big changes H-1Bs.
Yes, H-1Bs.
Yeah.
Go ahead.
Okay, so H-1B is going to change dramatically the wages that it will require for H-1Bs. This is going to be a combination of Department of Labor with USCIS. Okay. Typically, you're going to file what's called labor condition application for an H-1B. The Department of Labor will determine what that salary is going to be like for that particular level, education background, experience, et cetera, whatever's being included there, and particular category, right? What happens in that case? They now expect that on average, the difference is going to be, Stephanie, I think we saw in the neighborhood of a level 2 is going to be in the neighborhood of 48% higher salary.
Yeah. There was one that was even 60 something percent. And they're basically going to request a fee that is higher than what an American would be paid, which is substantially different to the current standard in H-1B practices. And then Gil, essentially what you're saying is level 1 wage is absolutely not going to happen. Level 2 wage, I still think is going to be extremely rare to see that this is going to be accepted. We're looking at level 3 and 4 wages and higher wages significantly.
Yeah. I would imagine we're going to see a drop off in H-1B applications. Okay. Well, this is the reality. There's 65,000 visas for bachelor's degrees, an extra 20,000 cap for master's, U.S. master's degrees. I would probably venture to say the U.S. master's cap's probably going to be pretty solid. Those are already salaries that typically are going to be rather high. But the bachelor's cap, generally, you're going to have over 200,000 applicants in any given year for that cap, Stephanie. So the reality is that I would imagine they're still going to eat up the cap. The 65,000 are still going to go, but instead of 200,000, maybe it's 120,000. So you have a 50% chance, kind of like what happens in the master's cap, to actually get in and to win a cap number. Okay. Last piece of news: student visas. Be on the lookout. Very soon, they're going to put an end date to student visas, I-94s. You're not going to just have duration of stay. Keep in mind, it is your job to always check your I-94, to review your I-20s, to make sure you are in current legal status in the United States if you're a student. Be mindful. Coming up, the next I-20s you might be receiving will no longer have duration of stay. They will have finite end dates, potentially. Look out for this. This is an important thing for students to be mindful of. No longer just duration of stay anytime you're studying. No, you came to study this particular program. It has to be finite. This is part of the administration policy changes for immigration. If we have a different political situation next year, it might not happen. Let's assume it will happen. So you have to be mindful of it. Stephanie, let's go to the questions.
Well, actually, Gil, what I wanted to touch on really quick was one more question that we've received with a lot of frequency.
Sure.
I-765, we haven't addressed this with our English audience. You are, in fact, using the current edition on the website, not the new edition, not the new fee yet. It's a question that we're getting a lot from our English-speaking clients. So continue to use the form that is available on USCIS, despite the fact that it's not the new form, right?
Wow, that's a great question. We've been getting that a lot too.
A lot.
I always go with, first thing I do, we check the edition date that's being accepted currently, USCIS, whatever it was the day that you filed, whatever edition date they are mentioning, that is the edition date. If you're ever nervous about that, print out the I-765 page on the USCIS website, open up the little tabby that says edition date, print that out clearly and mail that in with your form and say, hey, I'm using this edition because this is the version of the form. Highlight the version, and just submit it. That's just a little tip of how we do that whenever we're a little bit confused as to exactly which version we should be filing with.
Perfect, Gil. So let's go to the questions. I believe our team might be popping up one question very soon on the screen. Sure. Before they do that, I'm going to tee up the first question to you from Vero Garcia. Can you help me? My husband submitted an I-130 petition. I'm in Mexico. He is a U.S. citizen and they accepted it. Can we apply for premium processing to make the process quicker?
Vero, I'm so sorry. Unfortunately, there's no premium processing. So they already accepted it. I'm assuming you mean by that they received it, that it's not approved yet, right? So there's no way to do a premium processing on an I-130 petition. By the way, with all these new premium processings that we're talking about, Stephanie, I do not believe that I saw on there an I-130 petition. No, so they're not doing this for I-130 petition, guys. So there's not going to be the ability to do the premium processing, unfortunately.
Okay, beautiful. Thank you so much, Lorraine. Okay, next question is going to be from Carmen Castro. Her question in Spanish is going to be quick translation. Okay, so she's asking how we can get a complete copy of her case from immigration in the case that she did not maintain a copy of her case. So what you can submit, Carmen, is a FOIA request, FOIA. The important part to know is that the person who filed the petition, which in many cases is going to be the petitioner, and it may not be the beneficiary. The petitioner is the one who could submit the FOIA request. If you look up USCIS FOIA, you can submit this request. This usually does take a long time. I had a client actually who told me that they applied for a FOIA request about a year and a half ago, and they finally received the documents, but there is a way. Make sure it's submitted by the petitioner. Next from Valeria Gill. For the I-140, my spouse and I, should we have some sort of minimum amount of time being married? We're going to get married soon and then subsequently submit the form.
Yeah, for an I-140 petition in particular, there is no requirement for this. This is not, I don't feel there's a requirement for this for, other in I-130 either, to be honest with you. My opinion's a little weird, probably not common. I would say most attorneys might tell you, no, you should wait to show that you have a valid marriage. I am not of that opinion. If you have a valid marriage, don't worry about it. Okay. If you're able to document your marriage, don't worry about it. You could be married, a few months, and now you're part of the I-140 petition. You're filing the I-45 with your spouse on the basis of being married already. Okay.
Okay. Next question. Fab. Hi, good day, lawyers. Do you need to wait 3 months to get married in the United States? All documents must be post-marital date when I-45 is requested. So Fab, it's an excellent question. Yes, we do recommend getting married after 90 days. Why? Because when you enter as a tourist, you are entering as a tourist and you're presenting yourself as your intention is to tourism, right? Per USCIS and per law, you can have a change in your intention of what you actually came to the US to do after 90 days. This has changed. The new rule is the 90-day rule. So after 90 days, you can, in fact, be able to express that your intention to enter the United States did change. You no longer attempt to be a tourist, or you no longer intend to be a tourist. You now intend to be the spouse of your US citizen, right? So we do recommend waiting 90 days prior to getting married. And then after that, you would submit I-130 and I-45 together. I would recommend doing so before your status expires.
Carolina
Rivera. I am an American citizen and I'm going to ask for my brother who lives in Colombia. How is that petition? Does it take many years? I understand it takes many years. Can he continue to live in the United States while she files an I-130 for her brother?
Right. I think she's requesting, can he come in and out as a tourist during the time that this I-130 petition is pending and he's waiting for the consular process? Carolina, yes, he can. He can enter and exit the United States as a tourist as long as it's a valid tourist visa. Obviously, do not overstay here in the United States is very important. I don't mind if you come in and out. It's such a long process. Her question is, should he disclose something about it? Well, of course, he needs to respond if they ask him, Stephanie, if they ask him upon entry, do you have the, immigrant intent, or do you have the intention? Or is somebody ever filed a petition for you? Yes, obviously, tell the truth. Do I volunteer that information? No, I don't. I think it's important also that his intention is tourism, okay? Not to immigrate to the United States, because it's not, okay? So that's something to keep in mind. So I don't have a problem with that. Yes, he can come in and out. He cannot live here in the United States as a tourist when a 12-year petition is pending. Okay. I think we had a flash of a question.
We have a question from Everton.
Sure.
Hi, good afternoon. I'm Brazilian. I applied for a job in the United States in March. A list of eligible people was established and I passed the first stage of the selection process. After that, I didn't receive any notification from the company until July. In July, the company asked me to apply again for the same vacancy to establish a new list of eligible. The only difference in the ad was the salary. I signed up again and passed again. Now I'm waiting. Wouldn't this reopening of the recruitment and selection process and change of salary to the same position not be the first part of PERM? So you can run, the company can run a second round of ads, and it can be with a different salary as long as it meets the prevailing wage or exceeds the prevailing wage. Now, the important part is that second period of recruitment had to have begun before the prevailing wage expires. Prevailing wage expires usually within 3 months of the day they submit it. At the bottom of the prevailing wage, it says the date of expiration. As long as the second round of ads began before that date of expiration, you are fine, and the company can use the second round of ads.
I'm concerned there with the change in salary.
Right.
Okay, so I'm concerned with that. So two things to be mindful of. The change in salary, it's fine that it's more. Okay, my concern if it's potentially less. Okay, and number two, if the original prevailing wage, he might have to file for a new prevailing wage. Be very careful with that. You need to figure that part out, because if you don't figure that part out now, unfortunately, you're not going to figure that out until almost a year in the future.
Much later.
Okay, so it's going to be a mess. So I would figure it out now. Okay, next question.
I think, let's see. Okay. Giuseppe Di Benedetto, I did application for a permanent residency in 2016. No answer from USCIS in Miami. Does the new public charge rule apply to him, Gil?
No, I would say no. I mean, that's those are for filings from February 23rd, 2020 or prior. If I'm wrong, Stephanie, let me know. But as far as I'm concerned, as long as we filed the case prior to that, no. Can they ask you public charge questions? Of course they can. Yeah.
Especially at the interview, right, Gil?
Yeah. They could ask you if you have health insurance. Are you currently working? They could ask you for your tax returns. They're going to ask you for all these things. What type of green card I think is important as well. Is it based on employment? Is it based on marriage? If it's based on marriage, you have an affidavit of support. You have somebody that's petitioning for you. Okay, and there should be either a sponsor in the affidavit of support or a joint sponsor affidavit of support that is going to become financially responsible for you, Giuseppe, in the future. That's why they did this affidavit of support. So since you have that individual in a family case, typically it's not going to be an issue with the even if the public charge is applicable. Okay.
Alexandra, she is a U.S. citizen living in New York. She requested her 2 stepchildren. The priority date is February 14, 2020. How much longer? Alexandra, I would say I-130s right now for a child are currently taking probably in the neighborhood of a year. You're within the time limit. And also a good thing to note is, in order to check if you're in the time limit, go to USCIS processing times, look it up on Google, and it'll tell you where you are. If the date on the screen has already passed, let's say it says that they're adjudicating March 2020, then you could submit a formal service request. For now, you're within the times. I wouldn't expect a response until at least the beginnings of next year.
Okay.
Go ahead with the one on the screen. Go.
Sir and madam, thank you for this info. You've mentioned that being in the U.S., even on tourist visa, can expedite the process with the synchronized submission of the docs. And this is exactly my headache dilemma right now. I'm in a relationship with a green card holder, really important, green card holder, not a United States citizen. In 3 months, we'll be married in my home country where I am right now. Can my application for a tourist visa now be regarded in future as a conscious hiding of my immigration intention? How big is this risk and possible consequences? Look, if you're getting married in your home country, okay, and you're going to then enter the United States in the future to file a change of status over here after 90 days, there are risks involved with that. Of course there are, okay, because you're already married prior to entering the United States. It is pretty firmly established that upon entry, your intention, Stephanie, if it's 90 days, 120 days, 3 years down the road, when you enter the US, you're already married and you filed the green card application. Okay. So I think that scenario specifically is the perfect example of a case that you should probably process through the U.S. consulate if you want to do the I-130, or you might want to consider doing a fiance visa. Initially, seems to me you already have a tourist visa. If you have a tourist visa, you might want to consider doing all this process over here, okay, and not necessarily outside the United States. On balance, I do not like the situation where you're getting married outside the United States and entering again. What is the risk? That they deny everything. That is the risk, unfortunately. Okay.
Blanca Mejia. Due to the pandemic, she was stuck in the U.S. Her I-94 is valid through June 16th, and she was able to find a flight that departs on July 3rd. Will she lose her tourist visa status? So, Blanca, that's a great question, and the likelihood is probably yes. Essentially, as long as you're going to overstay, even if it's by 2 weeks. Technically, there's the 10-year bar. Will you be prohibited from coming to the U.S.? Unlikely, but you will likely have to go get a new tourist visa. My recommendation, better for you, since you're already really kind of putting that tourist visa at risk, is apply for a B2 extension, apply for an I-539 extension, even though it's only for 2 weeks. Make sure it arrives at USCIS prior to 16th of June. Wait.
By the way, she's gone. She's
gone. Oh, hold on. She's gone.
Sorry, I didn't want to
interrupt. I would try and apply for a new tourist visa already. I wouldn't go with my existing tourist visa. I would apply for a new one already at the U.S. consulate. Gil, sorry. What would you do?
Yeah.
Same thing?
Yeah. Yeah. I mean, like, this is important. People don't know that if they pass the day of their I-94, okay, even if they filed for an extension, a change of status, whatever it is, USCIS's opinion is that that visa in their passport that is connected to this legal status in the US is no longer valid for reentry in the future. Okay. I would even venture to say not just tourist, any visa. Okay. That is probably true. You are not going to be able to enter again, even though the visa in your passport is valid. I would apply for a brand new visa, not right now, Blanca. It's really important. I would not do it right now. I would allow a prudent amount of time to change. We are also getting a lot of questions, Stephanie, about this. Because of the pandemic, I was stuck in the United States. Okay. I had nothing else to do but to stay here. Has USCIS stated that, don't worry about it, your visa's fine? They haven't. So if they don't say this, I don't believe there's a policy change. And if there's not a policy change, you try to enter through the airport with that visa definitely after overstaying, you're toast. But even if you applied for an extension, I would also say that visa is no longer valid anymore. Okay?
And that's the crazy part, Gil. They won't know that it's no longer valid until you're at the airport. So that's why the advice is to really go get the tourist visa issued again in a prudent amount of time, just like Gil says.
By the way, there's not very much information about that on the USCIS website. There's not very much information. Guess how you learned that, Stephanie?
In practice today.
In practice. That's why they call it. Attorneys have a practice, right? And that's the reality. There's not perfection; it's practice. And unfortunately, I think many people have learned the hard way, Stephanie. This is the problem. You try to enter with that visa in the United States at the airport, they deny your entry, and you're facing potentially up to a 5-year bar. Okay. For trying to re-enter on that, because they might believe that your intention is to immigrate to the United States, and you've created a huge problem for yourself.
Yeah, absolutely. Okay, Gil, next question for you from Ira Alvarez. I have an important question. What types of petitions are available in order to request a visa for a juvenile? The juvenile is in the United States and has been here since 2016.
Illegal out of status? I'm not sure.
I'm assuming out of status. Maybe she's asking about special immigrant juvenile.
Nah.
I mean,
it depends the situation. Ida, you might want to go ahead and have a formal consultation with us to explain the facts to us, for us to understand. Off the top of my head, yes, there is a special juvenile immigrant visa petition, Stephanie, potentially, given a certain situation and circumstances that he may or may not be eligible for. Look, once the person's out of status, the reality is that the options, let's just say you have usually 3 options, okay? If you're lucky, okay? You're out of status, it's probably 0 or 1, okay? And that's the reality, So let's go ahead and have a formal consultation and be happy to do that for you.
Daniela, my husband's I-45 case is ready to be scheduled for an interview. It said so on July 22nd, 2020. When do you think this interview will be? Daniela, we have had a series of notifications of interviews that are forthcoming. We believe they will become starting in the near future. Even though it says it's ready to be scheduled, we haven't seen, Gil, many marriage-based interviews. I've been seeing more so the employment-based, but marriage-based should be rolling out very soon within the next couple months. It's coming. It's coming. Everything's sort of on pause because of COVID, Daniela, and it really depends on the local offices, how many people they're seeing. They are happening. They're just happening slowly. They're trickling in.
I think we've seen March and April appointments be set. Okay. So if you're in July, you're probably, I would say, 3 months away, maybe December, more likely January, probably. If you're in the Miami office or South Florida, I would say get ready for first quarter next year. Probably.
Okay. Vale Widower. She's Argentinian. She entered the country legally 19 years ago. She has been working for the past 13 years. Her husband, who is an American citizen, requested or petitioned her on September 29th. And what is her situation as far as a public charge for her income and for his income? They both have good incomes.
Great. Is that you or me? I'll go. Yes, every case that was filed after February 23rd, 2020, vale, you're subject to the public charge law now. If you did not submit Form I-944 because that day it was not required, October 13th, okay, every filing after October 13th that is required, they will reject your I-45, Stephanie. If the I-944 form is not part of that, you will be getting a request for evidence for that form. Yeah. I have poured over that form recently, and it's we need to do a separate video on that.
Definitely.
I think we should probably consider doing that pretty soon. I think it'll be helpful for people because there's a lot of, if this, you must submit this situations where it's even difficult for attorneys to realize it. Listen, attorneys are not accountants. Okay. Right. They ask you for things like all your list of assets, all your list of, debts. You need to have a credit report. You need to have an IRS tax transcript, plain, emphasize plain transcript, not certified. Okay. Plain transcript. But I'm sure people are not submitting that stuff.
Yeah, absolutely.
Okay? I'm sure. So you're going to see a lot of requests for evidence. You're going to see all that. And anything after October 13th that doesn't have that exactly how they're requesting it, they might reject the entire thing. Okay. So you need to be careful there. So it's great that you're making a high salary. Fantastic. You're going to have zero issues. However, you must submit that information when they request it.
Maria Violeta, she is Mexican. He is a U.S. citizen. They're about to get married in Dominican Republic. Are they going to have an issue when they're doing her paperwork? No, Maria. Basically, wherever you get married, you are valid. That marriage is valid everywhere, right? As long as it was valid in the place where you got married, as long as you were validly married in Dominican Republic, you will be validly married here in the U.S. Just make sure you have a copy of your marriage certificate, and you are good. Have fun in Dominican Republic.
Next.
Lorraine. Gil, she would like to know if asylum residency benefits a minor stepchild who is not in the country.
Lorraine, it does, as long as you do it in a finite amount of time. I am not an asylum specialist, but I suggest you speak to one. You have to file what's called the I-730 petition. This is a petition where an asylee files for their child under the age of 21 or spouse that is currently that's currently outside the United States. Stephanie, this is a following to join petition for asylum. That's what that is. Okay. You do that with Form I-730. Look into it, but definitely speak to an asylum professional regarding all that. If you would like to write to us directly, be happy to direct you to one.
Hernan Koch, great question, Gil. He's Argentinian. He's asking if he could do his petition for his E1 visa in Montevideo because Buenos Aires is not currently processing e-visas. Have you had that situation lately?
The suggestion is you file where you live,
yeah.
Okay, regardless of your nationality. Okay, I have been filing where the individual lives, even though they are not a national of that country. I'm going to say, Hernan, you're probably stuck to Argentina right now. I see them moving around November for you to have an idea. Keep in mind, you have a huge backlog. Okay. We have various cases that we filed during the summer in Buenos Aires, E1, E2 visas. Those cases are still pending interview right now.
Perfect. Enrique Medina, he has his, he filed an I-130, marriage-based, and they got a request for evidence that they're missing the I-693, actually a courtesy letter, which is now a notice of deficiency. Essentially, they're saying, he's asking, his attorney says they could wait for the appointment to take the medical exam. Your attorney is correct. I would just do the medical exam, take it with you in the sealed envelope, and take it to the appointment. Basically, they're not asking for you to submit it in that notice of deficiency. They're just letting you know that we will need it eventually.
Enrique, do not take the medical right now. Okay. Right. Take the medical exam when you receive the notice for the interview, not before.
Exactly. Because it expires. The medical exam expires. So take it as close to the interview as possible. Okay. Enrique, actually a quick note, guys, if you can please try to only ask your question once, because if not, we get a little confused with the questions. So Enrique has a repeat. Gil, Valeria Lopez, do I need a minimum of time for having been married for filing the I-140? We already answered that question. Luis, can you guys talk about interview waiver for employment-based AOS? Do you see these happening?
Yes, Luis, I am seeing it. That was always what we would see, Stephanie, prior to February 2017. It was interesting. Probably like 2007, and before, you would see a ton. It was how it is now. But I'm talking about even perm-based cases, we would have to assist that interview with the petitioner and the beneficiary. So the company representative would go with me to the interview with it was crazy now you think about it. So they said, we really don't need to do this. We only need to interview certain types of categories. Luis, I do see this happening right now, which is fantastic. We have a ton of people getting their green cards without having to actually be interviewed in the EB1, EB2, EB3 categories. Marriage base will always have an interview.
Absolutely. And we have had the situation, Gil, where we already have had clients that they've gotten their green card in the mail and they never got the interview notice. So that's good news.
Yes.
Kingsley Okoro, how can someone who is on removal and facing first court hearing January 2021 continue to work after expiration of work authorization? We're not exactly experts in removal and deportation proceedings, but from what I understand, if you're already in court, I don't think you can request a work authorization extension. Gil, any correction there?
I'm assuming it is probably an asylum or something like that. So it's an individual that had an asylum after 151 days of having the asylum pending, applied for the employment authorization document. Kingsley, now you are in front. Your asylum was denied. You're now in front of the immigration judge. There are ways to do that. Typically, your attorney, this is my experience in the past when I did this type of work, we would get something from the court, have it certified, be able to file it with USCIS, and they would renew that EAD. It depends what stage you're at, what's the basis of why are you in court. There's a lot of factors in there. I definitely suggest if you're in court, you find an immigration attorney.
Berta Moreno, they approved her O1 extension with her in the United States, but on the I-94 website, they haven't changed the date, and it appears with the old entry date and the old expiration date of the O1. Berta, that is absolutely normal. What's going to happen is when you apply for an O1 extension, the I-94 changes only on your approval notice, not in their online system. So if you look at your approval notice, the bottom left-hand corner is going to say the new I-94. Usually the number is the same, but the dates are different. That is what you will use. Do not expect the I-94 website to update until you depart the country and re-enter.
Pierre asked us, if I requested an extension for a tourist visa and I still haven't received an approval, I see the cases for an I-539 is on cases April 2020 and I submitted in May. Be very mindful of a few things, Pierre. Number one, whatever date you put on that I-539 requesting extension through, that is the date, usually after it's approved, that they're going to approve the extension through. Meaning, if you're getting close to that date, you're now going to have to figure something out to go ahead and file to a different category, extend the tourist again, or depart the United States prior to that date. I like the idea of departing if I can, okay, prior to that date, even if I don't have the approval yet, Stephanie. But this is the most important part of what I'm about to say. Make sure the biometrics were completed already. Because if you depart the United States prior to your date and you did not complete the biometrics appointment, guess what? They're going to deny that extension only because you didn't do the biometrics, not because you did anything else wrong, okay? So I would say if that's the situation, we're filing second extensions. Biometrics appointments are coming in. They're starting to flow little by little. So if you've done the biometrics, I don't mind. You could leave prior to that date or do something else. If you haven't done the biometrics, we need to consider a little plan there, okay?
Okay, I believe our team posted a question, or actually just a statement from Victor Yeura, who I believe has been on our lives before. His fingerprint appointment was canceled in March, and now USCIS has rescheduled it for next week in Los Angeles. Victor, that's great news. And that's great news for our audience. Yeah. So we know that Los Angeles is in fact rescheduling fingerprint appointments. That's good because now you know kind of what's going on the West Coast there. Mm-hmm. And you're looking at, I guess, approximately 6 months. Right. So it's like for that fingerprint appointment to be rescheduled 6.5 months. So that's right. Very good news. Cool Mind. Hi, can I apply for EB green card if I'm out of status? I'm a civil engineer. My work visa expired. I did a lot of job experience here. Yes, you can if you've been out of status for less than 6 months. If you've been out of status for more than 6 months, Cool Mind, you cannot apply for an EB green card. Technically, you can, but consular, and it's a disaster. He's been illegal in the U.S. Yeah, the consular officers are giving him a green card, and it's going to be a mess probably. Israel Polanco, what happens with the 18 months extension is about to expire and we haven't received the appointment for an interview for the I-751? Go.
They go ahead and send you a brand new one. If they have not sent it to you yet, call USCIS.
Okay, I'm going to go with the questions on the screen. Yep. Hi, thank you for everything. It's really helpful. Me and my husband have a baby together. Can I bring the child to the interview? Absolutely, yes. Currently, the situation with COVID is interesting because they are limiting the amount of people entering. So I would say if the child is, I don't know, under a certain age and it's easy for you to bring the child with you, yes, bring the child, especially if it's a shared child. It's a great way to show that you guys are really married. But if the child is a little older, maybe try and see if you could find a way to keep them at home. Because of COVID, they're very limiting how many people can walk into the interview.
Can I petition for my mother being a resident? You cannot. You must be a United States citizen to petition for a parent. Do you want to go back to our list here? We have a couple maybe we skipped.
Okay, so I'll go to the questions on the list then.
Yeah.
Ira Alvarez. She is a chemical engineer with 34 years of experience. She'd like to request permanent residency in the US. Is it possible with this short synthesis of my curriculum? Absolutely, Ira. Off the top of my head, I think of the EB2 NIW. It's a beautiful option for individuals who are professionals, have a degree, have many years of experience, and you can actually self-petition. It's not a company petitioning for you. And then there also is the option where if there's a company interested in the US in your work, they can also petition for you. Have a consultation with us. We have a lot of options for someone with your type of CV.
Juan Carlos.
Go ahead. I'm waiting for my interview for my green card in the consulate. My spouse's visa, tourist visa, is about to expire. Should we renew it prior to the appointment at the consulate?
Juan, probably that will be denied because of immigrant intent. So since you already are waiting for the green card appointment to have the green card issued, the immigrant visa issued, I would suggest probably not doing that because it's likely just going to be denied anyways. Depends the consulate, depends the circumstances around it, depends your country ties. By the way, I'm assuming since she's your wife, she's also immigrating with you. If she is not immigrating with you, that is a different situation. But if she is immigrating with you, I'm assuming it's yes, then I probably would not request that B2 extension.
Valeria, my spouse works for 2 U.S. companies as a freelancer remote in Colombia. If we file the I-45, he is receiving the funds in the U.S. bank account. Does that count like he's working in the U.S.? Well, Valeria, one important point here. If you're filing an I-45, that means he's in the United States. So the work he was doing while he was living in Colombia, I don't see an issue that the money was being deposited to a U.S. bank account. Okay, that happens. Sometimes people say it's more convenient for me to receive the money there. But my concern is more so if you're filing an I-45, that means he's already here. And any work that he would have been doing here, it's no longer remote in Colombia. So yes, that could potentially be an issue and a red flag because they might in fact find that he is working without work authorization because he is here. So that's an important point of clarification. When did the work stop? The work stopped when he entered, I'm assuming, and I hope so.
Yeah, it's illegal work if he was in the U.S. Yeah. That's how they're going to consider it. Yeah. Tiger, I don't see his question. Sorry.
Duck.
Duckao?
Yes.
I like that. Okay.
Go ahead.
My U.S. spouse.
By the way, with the icon of the duck.
It's exceptional. My U.S. spouse filed an I-130, I-45, and I-765 based on marriage, and USCIS rejected my I-765, arguing that we didn't send the payment. Isn't the fees including the I-45? Have you guys had similar issues? Yes. Well, I haven't had the similar issue. You got to be careful there. There was an immediate change, and then they backed out the change. Yep. So they could have rejected the I-765 also because of the wrong form, number one. It's back to the old version of the form. And yes, you are correct. Currently, it is $12.25 as part of the package. They should not have rejected that if you filed it during the dates that was the correct version and the correct filing fee. If you filed in that little window of time that it was not, that's the reason it was rejected.
Belly asks, her U.S. citizen spouse petitioned for her. They're currently living in San Diego. Her I-94 expired. Can she travel domestically with just her valid Mexican passport? Belly, you can. In fact, for domestic flights, really all you're going to need is driver's license. But I do recommend taking the passport as well. You can travel domestically even though your I-94 has expired. Okay, Gil. From Rena. Her OPT program terminated in will terminate February 9th. And she just presented a adjustment of status petition I-130, I-45. What should she do if the green card petition has not been approved prior to the OPT expiration date?
If you filed RENA in I-45 already, your legal status now becomes green card pending based on that I-45. That is regarding your legal status. You have a different issue, which is your work authorization, because your OPT is going to end February 9th. So it's two issues. One is my ability to continue working past February 9th, Stephanie. You need to file 120 days before February 9th. You need to go ahead and file your I-765 based on the marriage case, and they will send you and extend you a year on that. What happens many times for OPT, and I've seen it many times, if you file too soon, the employment authorization, you know what they do, Stephanie? They go ahead and sit on the marriage case. They will go ahead and approve the EAD, the new employment authorization based on the marriage up to your end date of OPT, February 9th, meaning you're going to have to file for it again. So that's a mess. The student, for some reason, this is like a system glitch or whatever. So just do it within 120 days and you should be fine, February 9th.
Okay. FXR Pioneer, how does the I-864A work? So I-864A is going to be related to basically the Affidavit of Support. It is known as sort of a contract between the third-party individual and the sponsor, which says, should the beneficiary have some sort of issue in paying fees, like, for example, medical fees, or should they not be able to pay for certain things in the US in order to not take public benefits, this person is contracting and is saying that they will, in fact, pay for fees, and they are serving as a second sponsor, a second person who confirms that I can substitute. Now, Gil, this is an excellent intro to what we've been seeing lately and what the changes that are forthcoming with immigration, which is immigration is now going to start tracking people who sign affidavits of support as joint sponsors and as principal petitioners. So before, to be honest, if you signed it, there wasn't really a repercussion if you didn't go forward with it because USCIS wasn't following up. They're now making adamant statements that they've created an entire system wherein they're going to follow up and they're going to make sure that if the beneficiary truly cannot pay for some sort of service, they will potentially garnish the wages of the joint sponsor or of the principal. It's very important to know that there are repercussions now in the future forthcoming.
Yeah, that's called, I think it's called the SAVE program.
Yeah, I think something like that.
If people want to read up on that, it's called the SAVE. Just maybe put something like Affidavit of Support, SAVE, S-A-V-E in capital letters. It's an acronym for their program. Check that out. That was released recently in the last 30, 45 days, that information. It's worth a look at that, I would say. Morelia asks us, hello,
do fingerprints expire? Go.
Do fingerprints expire? Fingerprints typically expire within 12 months. So if they will request for you to take new fingerprints if the fingerprints are past 12 months. If you take in fingerprints within a 12-month period, biometrics, you generally will have a waiver of the biometrics requirement and they will proceed your application without it.
And her follow-up was essentially, is it weird that they had her go to the interview and then they asked her to go do fingerprints again?
No, that happens a lot. That's good news. Probably they're approving your case because if they're denying you, they're not going to waste time doing biometrics again, in my opinion.
Maria Varela, they approved her residency petition through VAWA in July 2019. She still has not received her green card or employment authorization, and it expired. So Maria, I want to check something with you. Did you receive a prima facie approval or did you receive an approval of the I-360? Because a lot of times there is a confusion, okay? So VAWA cases are very particular where the I-360, when you submit it, you're gonna get what's known as a prima facie approval, meaning based on the limited documents that we have in front of us, we believe you will probably qualify for this and we will be able to continue with it. But for now, you can remain in the United States while we adjudicate it. And this shows that you can remain here validly, but we still have to adjudicate it, okay? So if that's the case and you only have a prima facie approval, the case has not been approved yet, which means you're not gonna get your green card yet, and you do have to submit a new I-765 in order to renew your employment authorization. Now, I think that's the situation. If in fact your I-360 was approved, your I-485 potentially is still pending, then submit a new I-765 to renew the employment authorization. You will not get the green card until the I-485 is approved. Perfect. Good.
So
that's how I read it, right? That's what I'm assuming. Yeah. Ricardo Fernandez. In October, he is going to submit the I-485. How long do you think it's taking for an interview?
Depends, Ricardo. Ricardo, depends the category, depends if it's marriage. If it's marriage, I would be around a year and a half, probably 18 months. If it's a different type of category, it might be more time, might be, depends. Employment base is probably going to be less than 18 months for the interview, if there is going to be an interview. Let me bang a couple of these out. Fabian, I had an O1 visa. I overstayed 121 days without status. Whoops. Will it be an issue to reapply to another O1 visa? Yes, it will, Fabian. If you stayed here 120 days without status, I'm hoping that you left. Okay. If you left under 180 days from the end of your I-94, I think you're probably going to be okay. It also depends when all this happened. Okay. I do find that more time is a valuable thing, and more time that has passed since this particular incident. If this is something that just happened recently, I would really hope that you're outside the United States. So you're not subject to the 3-year bar as long as you departed under 180 days. Once you depart over 180 days, guys, then you're subject to a 3-year bar. If you stayed more than 1 year in the United States without legal status and then departed the United States, you're subject to what's called the 10-year bar. This idea is called the 3-year, 10-year bar. It's really important to never be more than 180 days without legal status in the United States. Once you're past that amount, it becomes quite difficult to obtain legal status in the future.
So Gil, we're getting close to 1 p.m. We have a couple more questions we'll go through from Ricardo, from Eduardo. If you have any other questions, please feel free to submit them now. And any other questions you may have or any recommendations for your videos you may have, go ahead and submit them in the comments and we'd be happy to do it. As Gil said, we'll be working soon on a public charge video, okay? So Ricardo asks us a question. He is currently here on a student visa. His spouse has a pending asylum petition and she has travel authorization that she requested. Can she go back to her home country, Venezuela? Ricardo, no. She asked for asylum from Venezuela. She cannot return to this country. It is considered an abandonment of the asylum petition. You're requesting asylum because you're saying that you cannot return to your home country. So if you use the travel authorization to return to your home country, I would say it is a guarantee that asylum petition is going to be denied and she will have a lot of trouble re-entering the U.S.
Eduardo asked us a common question right now, which is, I did the affidavit of support for my spouse. I petitioned for my spouse. The interview is going to be soon. I lost my job. Initially, I did the affidavit of support. I did everything I had to. What I'm seeing typically, we're already past the affidavit of support state, Eduardo. So very, very likely that they're not going to ask you about it. They may ask you about it if you're currently working to provide pay stubs, okay, or to provide other forms of income. If you're not working, I would be prepared to take a joint sponsor I-864 with evidence that the joint sponsor is a United States citizen or a lawful permanent resident, with evidence that of their 2019 tax returns and with evidence of their recent payments and salary employment verification letter. I would prepare that or have somebody on the side. You may go to the interview and they're not going to ask you at all. They may request it. They're generally going to allow you an extra 30 days to go ahead and comply with that, bring it in or mail it in to them.
I know you love this question on the screen, Gil.
What is that?
How to find the right lawyer.
Well, I don't know. Here we are. Here we are, Bernie. I always say this, Stephanie, I'm not the right lawyer for everybody. So I do say that a lot. I think number one, it's experience. I think we're very honest on the things we're not that experienced in, and we typically refer you out to somebody else. If I am very experienced in something, I definitely want to do it. And I want to be given the opportunity to do it. I kind of plead my case there to do it, Bernie. So if you want to have a consultation with us, be happy to do it. Explain the case. Maybe we're a right fit for you.
Bernie, that's absolutely, ask for a consultation. hear what the person has to say, and see if you really, I would say, vibe with the person. If you know and you trust what they're saying, and you trust that they really have your best interest in mind, that's the way to go. And you want someone who, like Gil said, has experience in this sort of thing. So I believe those are all our questions for today. For those of us who are asking, for those of you that were asking questions in Spanish, we will have a live Q&A next Friday at 12 noon. If you have any other additional questions, and if you have something that's specific to your case that you want to go forward in and you want to ask specific questions, you can always contact us, info@beltranbrito.com. We will schedule an appointment. Gil and I review that email, so we'll be able to answer a question quickly if it is a question quickly, or address some sort of consultation. Gil, thank you very much.
Thank you. We're gonna do. Stephanie, you know what I'm thinking of doing? I'm thinking of doing hybrid: Spanish, English,
Spanglish.
Spanglish.
That is our specialty.
I'm thinking of just doing that, just so everybody feels comfortable that we're responding to them in their native language, a little bit easier for them. So I think maybe next time I'm going to do that. So we'll do Spanish next week. Then we're gonna. I'm talking to the media team. Media team, we're gonna do Spanglish, and we're gonna call it Immigration Attorneys Q&A Spanglish. English and Spanish questions, and we'll respond in the person's native language. Thank you so much, Stephanie. Thank you.
Our media team says we should call the series Arepas in English.
Oh, look at that. That is, why not? Yes, I do like that.
Thank you so much, everyone.
Take care. Bye-bye.